This is a continuation of our discussion about advocacy in court. In this unit, we will consider some of the theoretical underpinnings of the adversary system. We will also highlight Rules 3.6 through 3.9 that deal with advocacy. One of the philosophical issues that undergirds lawyers' work is how we feel about being agents for various clients. It is not uncommon for an attorney to hear, "How can you represent someone who has done X?" Various legal philosophers have addressed this quandary. In acting for others, does the attorney become implicated in the ends of the client? David Luban sketches out the adversary system excuse that is typically relied upon to answer this question. In this country, attorneys operate within an adversary system of justice. The adversary system is supposed to provide an impartial forum, formal rules, and an opportunity for each party to conduct his own case. It is argued that the adversary system permits the attorney to be zealous for his own client, since that is the only way that the client will have his day in court. And, as long as both sides have zealous advocates, the adversary system functions to find the truth. But one can question the fairness of the adversary system if each party is not represented by an equivalently zealous advocate, or if the tribunal is not impartial, or if the rules are not followed. So the adversary system may well justify the attorney's role as zealous advocate for her client, as long as all parties have zealous advocates. Luban further explores where zeal in advocacy is most justified. He suggests that zealous advocacy is most justified by the criminal defense attorney because she is facing the power of the state and because the defendant has certain constitutional rights that are implicated in the prosecution. Thus, the criminal defense attorney would be least morally implicated in his representation. He is representing someone against the great power of the state and someone who has constitutional rights to the representation. Because of these constitutional rights, the advocacy playing field, as between the criminal defense attorney and the prosecutor, may not be a level playing field. What about the civil litigant? Here Luban draws a distinction. Because the civil litigant does not face the overwhelming power of the government, and because she has no constitutional right to representation, the lawyer should not feel as free to be a zealous advocate for the civil litigant. Of course, the lawyer who is an advocate in a civil case should be zealous, but she cannot be morally justified in her zeal in the same way as the criminal defense attorney can. Finally, legal philosophers recognize that not all lawyers are acting to argue a case in the adversary system. Many lawyers are advising clients with the hope that no litigation ever ensues from their work. In that case, the adversary system excuse provides no cover for an attorney representing a questionable character. If the civil client doing a deal is a liar or a cheat, the lawyer cannot justify representing such a person based on the existence of the adversary system. Here, legal philosophers such as Luban argue that the lawyer is morally implicated in her client's cause. If the client is not facing the criminal enforcement power of the state, the lawyer should be morally accountable for how she chooses to use her law license, according to some moral philosophers. Let us now turn to the rules that touch upon these issues. Rule 3.6, Trial Publicity. Rule 3.6 deals with trial publicity. It provides guidance to both prosecutors and to criminal defense attorneys, and for civil attorneys litigating cases as well. The basic rule is that a lawyer who is handling a case should not make a statement to the media that will have a substantial likelihood of materially prejudicing the case. How would this occur? Most likely by the jury pool being tainted by news coverage. Subsection B provides a laundry list of things that it is okay to say to the media. These include the claim or offense involved, information on the public record, any scheduled next steps, and that an investigation is in progress. The attorney may also ask for help in obtaining evidence and provide warnings if the defendant is still a public threat. There are also certain well-defined statements that the prosecutor may make about the defendant and the ongoing investigation. However, Rule 3.6 permits a defense attorney to make a statement to the media that she believes is required to protect her client from the substantial, undue, prejudicial effect of recent publicity not initiated by the lawyer. This exception was clarified by the case of Gentile versus State Bar of Nevada. In that case, the defendant, arrested for drug possession, was the owner of a storage facility in which drugs were found. His lawyer issued a press release that suggested that members of the police force were actually guilty of owning these drugs. It was quite a scandal, and ultimately Gentile's client was acquitted. But Gentile faced charges for having violated the then rule by issuing a press release outlining his client's arguments. The U.S. Supreme Court approved such a press release to counter the negative press release that the police had been issuing. If you find yourself representing a case with high media coverage, please study this rule and this holding carefully. Rule 3.7 deals with lawyer as witness. This should have been covered with the conflicts of interest rules. However, in the event that it was not, let us highlight the most important issues. A lawyer cannot be both the advocate in court and a witness on the stand. There are a few, usually irrelevant, exceptions, such as that the attorney's testimony relates to an uncontested issue or as to the value of legal services. Thus, the attorney can testify to submit the contract and the bill. The final exception is if disqualification of the law firm would work a substantial hardship on the client. Finally, it is useful to note that this prohibition is personal. Attorney does not equal firm. Thus, an attorney can take the stand and testify about the client's matter, provided that the attorney's partner is the one presenting the case. Rule 3.8 deals with the special responsibilities of a prosecutor. A prosecutor for the state has a different responsibility than any other attorney. According to comment number 1, she is a minister of justice and not simply an advocate. Often, the prosecutor has the right to engage in decision-making in the same way that a client would, deciding what crimes to charge and what plea bargain to agree to. Thus, it is important to recognize that the prosecuting attorney has somewhat different powers and a somewhat different role than other attorneys. Rule 3.8a provides that the prosecutor must refrain from prosecuting a charge that she knows is not supported by probable cause. Subsection B requires that she make reasonable efforts to ensure that the accused has been advised of his right to counsel, the process to obtain counsel, and the defendant has been given reasonable opportunity to obtain counsel. Subsection C prohibits the prosecutor from obtaining a waiver of important pretrial rights from an unrepresented accused. Subsection D requires the prosecutor to make timely disclosure of exculpatory evidence. The U.S. Supreme Court case of Brady v. Maryland also requires such disclosure as a constitutional matter. Subsection E deals with the situation when attorneys might be subpoenaed before a grand jury. This rule states that the lawyer should not be subpoenaed regarding his client unless the information sought is not protected by privilege. In other words, the attorney learned of the facts in order to advise and assist a client crime or fraud. And the evidence is essential and there is no feasible alternative to obtaining the information. Subsection F makes clear that, except for the prosecutor's need to inform the public and for legitimate law enforcement purposes, the prosecutor must not make extrajudicial statements that have a substantial likelihood of heightening condemnation of the accused. Subsections G and H deal with defendants or convicts who were innocent of the offense. If the prosecutor knows of new, credible, and material evidence creating a reasonable likelihood that a convicted defendant did not commit the crime, the prosecutor should promptly disclose the evidence to an appropriate court or authority and to the defendant if the conviction was obtained in the prosecutor's jurisdiction. When the prosecutor knows of clear and convincing evidence that the defendant was convicted of a offense that he did not commit, the prosecutor is obligated to remedy the situation. Rule 3.9 deals with an advocate in a non-adjudicative proceeding. When a lawyer is representing a client before a legislative body or administrative agency, the lawyer needs to disclose that she is appearing in a representative capacity. This is the end of the second section on advocacy.